Bharat, from struggling for freedom to enjoying its freedom today, from Nehru ji to Modi ji, from PSLV-4 to Mangalyaan, and from its first computer TIFRAC to handling AI-based data systems today, Bharat has always been a developing country. Imagine going to a restaurant and having a robot at your service instead of a waiter, or being operated in a hospital and being treated by a robotic machine instead of your doctor. No, I am not narrating any scene from an exaggerated Bollywood movie. Rather, I am talking about instances that are happening around us today, in Kerala, in Chennai, in Ahmedabad, in cities of our very own country. Greetings to our respected judges and organizers. I am Rajlaxmi Nimbalkar, currently studying my 5th semester of BA LLB from D.E.S. SHRI NAVALMAL FIRODIA Law College. And today, I stand here to voice my opinion on the topic Artificial Intelligence and Legal Framework in Bharat. As Stephen Hawking rightly stated, the success in creating artificial intelligence shall be the biggest event in human history. Unfortunately, it might also be the last, unless we learn to avoid the risks. Artificial intelligence, as a term, was first coined by the American scientist John McCarthy in 1955, and today it is not very far away from being the future of science and technology. The partnership of India's think tank Niti Aayog with Google does definitely ensure developments in the artificial intelligence ecosystem in India. Now, the entire discussion is about how to bring this technology under the ambit of the municipal and international laws within the country. Why doesn't India have a legal framework which deals with artificial intelligence? So the questions are, does artificial intelligence have a legal personality? Does artificial intelligence have a locus standi? Now, the personhood of artificial intelligence depends on whether or not it can be made a subject matter to legal rights and duties. Can we hold artificial intelligence liable for criminal or civil acts? If yes, what would be the nature of this liability? Would it follow the principle of absolute liability without exceptions, as in the MC Mehta case, or a strict liability with a few exceptions, as in the Rayland Fletcher case? Can we expect artificial intelligence to form a contract and be bound by it? Can we give artificial intelligence copyright according to the copyright law? Now, our inability to answer all these challenges forces us to pay attention to the drawbacks of our Indian legal system to deal with artificial intelligence due to its nature and functioning. In the words of Betty Williams, there is absolutely no use of talking about problems if you do not discuss the solutions. So first of all, India must adopt a legal definition for artificial intelligence. The Companies Act talks about one-person company. If this is amended to a zero-person company, this creates scope under which artificial intelligence systems can be given a functional equivalence to a legal personhood. The cases where the breach of data protection is concerned, the IT Act of 2000 is the only legislation that touches this subject. Amendments and endepthing of Section 43A and 72 that safeguard the data privacy will be of some help to us here. Now, these effective IT laws have to be clubbed with effective and extremely careful contract drafting between the AI user and the AI developer to determine the parties' liabilities. Now, India is on the forefront of this entire revolution of creating a legal framework for artificial intelligence, and that is why Indian legislature needs a two-layered protective model. First one, having technical authorities in place, and the second one, having laws that are accountable for the acts or errors of the AI system. The time is now. If Indian legislators do not take action now, then we shall see the unprotected AI system leading to an unforeseen catastrophic destruction of the desired legal framework for AI in Bharat. Thank you.